forests. And you have all that water that could be used to...
Granted. All right, nothing further. We'll be in recess. And with
his letter after receiving notice. And so
State of Kansas versus Owen Solomon. County Attorney Jill Gillett for the state. Owen Solomon, are you here or your bondsman?
Washington State, and it was returned unclaimed. He did not go and pick up his letter after receiving notice. And so Mr. Solomon refused his letter, and the bondsman had been mailed and served. And that's second chance bail bonds.
Is this the crab fisherman with the girlfriend?
Yes.
Warrant remains active then, and judgment granted. All right, nothing further. We'll be in recess.
He has an attorney. It was last.
Yes.
I'm not sure if his attorney, if he has an attorney. It was last Chris Pate. He was still in federal custody, and they were supposed to call at 1:45 because they were having a hard time Zooming.
I think Missy had some information on that too. Did you not, Missy, on Gudenhagen out of state? What was that?
Yeah, it was an email from her office asking if we could do them first.
Oh, it was from Miss Gillette's office?
Yeah.
Okay. So now he's thinking he doesn't want to do them first.
I don't know. They're going to call at 1:35 because they are having a hard time Zooming.
Okay. All right. Give me just half a second here, folks.
Mr. McClendon and Mr. Favre.
Are we ready to proceed then?
Judge, I have a quick one with Mr. Favre if you want to take it up.
Certainly. Mr. Favre has a couple on the docket. Is that Betterson?
Betterton.
Betterton. And then you also have Ginger Blades, Mr. Favre?
And he has
Judge.
Okay. All right, let's take up Betterton.
The state will be dismissing Betterton due to some information provided in a co-defendant case.
All right, well, let's go on the record in 2024 CR 8, State of Kansas versus Rebecca Aline Betterton. Please announce appearances.
May it please the court, the state appears by Jill Gillett, County Attorney.
Ms. Betterton appears with counsel Joseph Favre.
And Ms. Gillett, you said you had an announcement?
Yes, that case will be being dismissed pursuant to information provided in a co-defendant's case.
And will that be with or without prejudice?
Without prejudice.
All right, Ms. Betterton, as your attorney may or will tell you, that means they can refile it if circumstances warrant it. But at this time, it is dismissed and you're relieved of further obligations on this matter.
Okay, thank you.
You're welcome.
The next one that we have, Judge, is Ms. Williams, and it should be fairly quick. I believe we're going to have a waiver on it.
Yes, it's the next two I have, the only two I have left, Williams and Blades, are both pretty quick. Miss Williams is at the jail and it's going to be for a waiver today.
Very well. right, Ms. Williams, let's go on the record in your case, which is case number 2024 CR 84 on the record in the case of State versus Donna Anita Williams. Please announce appearances.
May it please the court, the state appears by Jill Gillett, County Attorney.
Miss Williams is represented by Joseph Fabre, and she is at the Greenwood County Jail.
And how does she wish to proceed today?
Judge, we are working on a global plea in regards to this case and another, so at this time she'll be waiving her right to a prelim in this case, and we'll ask that this be set with Judge Ricky with the other case that she has, which I believe is currently set for October, I want to say 3rd.
3rd at 9 a.m.
That's right.
Very well. So, Ms. Williams, your attorney says you want to waive your right to preliminary hearing in this case. You do have the right due to the fact that the one and only count is criminal damage to property with a value of $1,000 to $2,500, a level 9 felony. As you may or may not know, a preliminary hearing is one in which the state of Kansas does have the burden of producing evidence to make it appear that this felony crime has been committed and to show probable cause that you committed this crime. Preliminary hearing is not a trial to determine whether you're guilty or not guilty. It's a hearing to determine if there's enough evidence to require you to stand trial, or in other words, to be bound over for trial. At the preliminary hearing, you have the right to be present with your attorney. You have the opportunity to challenge the state's evidence, to challenge the existence of the probable cause for further detention. You have the right to subpoena witnesses, cross-examine the state's witnesses, and present evidence on your own behalf. A preliminary hearing would apprise you about the nature of the crime charged and the sort of evidence you'd be required to meet if you were to stand trial. If you waive or give up your right to a preliminary hearing, there will be no preliminary hearing, however, and you will be bound over to the district judge for further proceedings. You will be required to appear at a later date before the district judge for arraignment, at which time you'll enter your plea to the charge against you. And until that time, you will be remanded to the custody of the sheriff until or unless you're able to make bond. Now, have you talked with your attorney about waiving your right to preliminary hearing?
Yes, I have.
And do you need any more time to visit with your attorney before we proceed?
No, ma'am.
Do you wish to waive your right to preliminary hearing in this case?
Yes.
Are you voluntarily waiving this right?
Yes.
Has anyone made threats or promises to cause you to waive your preliminary hearing?
No.
And are you in good health today?
Yes.
Are you taking any medications which might impair your judgment today?
No.
Mr. Favre, do you know of any reason why the court should not accept the defendant's waiver?
I do not, Your Honor.
Very well, the court finds the defendant has made a knowing waiver of her right to preliminary hearing after consultation with counsel. Ms. Gillett, does the state wish to waive its right to preliminary hearing?
The state does, Your Honor.
The court finds that the state also has made a voluntary waiver of its preliminary hearing. Therefore, the order of the court will be that the defendant is bound over to the district judge for further proceedings. And Missy, can we set this over for with Judge Ricky for October 3rd at 9, or do you know?
Yes, I believe so.
And Miss Williams, I'm going to order that you next appear by Zoom with counsel before Judge Ricky for arraignment on this case, October 3rd at 9 a.m. If you make bond, a bond condition will be that you reappear before Judge Ricky, October 3rd at 9 a.m. for arraignment. Anything further, counsel, on this matter?
No.
Very
No.
well. Ms. Williams is excused. Mr. Fabre, your next client?
Judge, I have Miss Blades, who I think is at the courthouse. She told me she was going to be appearing at the courthouse today.
Well, Ms. Blades, is she there at the courthouse?
I only have one here now, Your Honor.
Well, looks like she might, is that her? That's not her, is it?
No,
No.
that's not her.
She's not here yet, Your Honor.
Well, we'll
Okay.
give her
And
a few more minutes.
thank you, Judge.
Can we take up Budenhagen? They're on the phone with the Bureau of Prisons.
Is he available by video?
No, they're on my phone, my speakerphone. They're
I don't generally do phones only. I usually,
right. They are having a hard time zooming at the Bureau of Prisons.
I understand that, but I was telling Missy this morning, I really can't do much with him without having him here.
Right.
Well, I mean, if the feds are saying that he's there, I think
Yeah.
I trust that. And I think all we need to do, we need to get an evidentiary prelim date set. And I think there might be a warrant.
There he is,
Um,
and that's gonna
and-
stay active until I get him. This case has had a lot of activity on it, going back to first appearance 9/26/23.
Well, Judge, the only reason he missed last time was because he was in federal custody.
And as you know, that's not an excuse.
It's a reason.
It's a reason, but it's not an excuse.
We
All right,
on the phone, Judge, so that he can hear what's going on.
all right. We are on the record in 2023 CR 219, State of Kansas versus Michael James Budenhagen. Please announce appearances.
The state appears by Jill Gillett, County Attorney.
Your Honor, Chris Pate on behalf of Michael Budenhagen, who appears from federal custody.
Now, he doesn't totally appear because I don't see him. Is there someone from federal prison representing that the defendant is here?
Mr., can you hear us?
Yes, let me get my count.
Okay, he's gonna go get the counselor that's there because they're called in. Can you hear him at all, Judge?
Fairly, which one is he? Is he Samsung SM?
No, no,
Motorola?
he's on my speakerphone. You're hearing him through.
Oh, he's on your speakerphone. He's not even here.
Yes.
Okay,
His case manager's on there now, Judge, to verify he's at federal.
all right. Is there someone from the Bureau of Prisons with us now?
Yes, ma'am, this is Council Mallard with Bureau of Prison Force Service.
No, I
Can-
thought I could hear you, but what was the name again?
Councilor Mallard.
Counselor Miller?
Ballard, Mallard, MALLARD, and he's who we email with at BOP.
Counselor Mallard, did I hear that right?
Yes.
All right, and Counselor Mallard, what is your position there with the department?
I'm a correctional counselor.
Correctional counselor. And you know the defendant, Michael James Budenhagen or Budenhagen?
Do what?
Do you know the defendant? Can you vouch for him being the person present?
Yes, ma'am.
All right, and he's an inmate with which facility?
He's an inmate with FCC 4 City, Low.
Okay. And Mr. Pate, this comes on for preliminary hearing control. How does your client wish to proceed?
Your Honor, we'd like to have the matter scheduled for an evidentiary preliminary hearing.
And how much time will that hearing take, Ms. Gillette, if you know?
Judge, I'm gonna ask for an hour.
Okay. We're looking at, is that possession of meth, DUI, and paraphernalia?
Yes, and it's a stop by the Kansas Department of Parks and Wildlife Tourism.
All right. Missy, when can you give us a preliminary hearing for that?
And Missy, if we can have at least 30 days for the subpoenas, because we're also gonna have to do the order for hearing with the BOP again.
Okay. I have October 18th available at 10 o'clock.
Counselor, Counselor Mallard, is the 18th at 10 o'clock? Is that a time where the Federal Bureau can Zoom?
Well, I'm not going to be available that morning.